Was it? We'll probably have plenty of time in this class. Yeah, if you could just take one and pass it around. Well, we should have plenty of time in this class to answer any questions that you have. And that's something I wanted to say is that I have a presentation. It's actually a workshop. So we're going to do some back and forth, and there's some handouts going around. But feel free anytime just to jump in with questions. Try and keep it on track, and if it's not on track, just hold it to them. But if it's related to what we're talking about, feel free to jump in and we'll talk about it, and you should be able to get your answers. If you do have specific questions where you might be divulging some confidential information, try to make it generic so that we don't share that with everybody. So we'll go ahead and get started. I'm going to be giving the IP portfolio workshop, and I'm a patent attorney. I've been a patent attorney for about 12 years, but I also like to emphasize that I'm a small business owner. I started my own law firm a little over 7 years ago now. So I know what it's like to be a small business owner. I know the ups and downs and some of the scary times, especially of recent. But so in addition to being an attorney, I'm also a small business owner. So let's start by what is an IP portfolio. Well, a portfolio is just a group of assets. So think of your investment portfolio. Your investment portfolio might have bank accounts, stocks, bonds, or real estate. Hopefully in today's market, your investment portfolio doesn't have too much real estate. And then intellectual property is just an umbrella term for things like patents, trademarks, copyrights, and trade secrets. So an IP portfolio, or an intellectual property portfolio, is just a collection of your business's patents, trademarks, copyrights, and trade secrets. So a lot of the time business owners will come to me and they'll say, I don't have IP, do I? And so my first question back to them is, do you have a brand or a logo? Most businesses do, so you have a trademark. Do you advertise at all? Do you have any copy ad? Do you at least have a website where you're advertising? Most businesses do. So you have a copyright, at least one. And can just anyone run your business? Or does it take some sort of special know-how to operate your business? Most businesses have some special know-how that sets them apart from their competitors, and so they have at least one trade secret. So let's start with the handout. If you go to the first worksheet number 1, identifying IP. Are there any more handout?
I can't.
And there's a short paragraph here, if you can read it. It's just about a business owner, a restaurant. And if you can read through there and circle at least 3 different types of IP that you spot. I'll give you a couple minutes to read through that, and then I'll give you the answer. Does everybody have a chance to look through it? We just get partway through so we kind of know what what we're talking about. So here's the answers. Trademarks, Mr. Ribs. And the tagline that goes along with that, Ribs, mountain style. This business owner also has copyrights. They have a story on their website where they talk a little bit about their history, and they have pictures of the customers eating in there. That's all copyrightable. They have a unique menu. The menu is going to be copyrightable, the specific arrangement of the menu. And they also have trade secrets. They have certain contacts that they've made in the industry. They have certain pricing, how they price their products, and the pricing they pay for the products they get. The big one for the restaurant owners is probably going to be the recipes, and then just skills that they've developed over time that only they know. Those are all going to be trade secrets. Things that are not IP, that are often confused as being IP, are things like the company name. Mr. Ribs LLC, that's not a trademark. Mr. Ribs is when it's used to identify the restaurant services, but the company name is not a trademark. It's a fine distinction, but it is a distinction. Evergreen restaurant, that just describes where the restaurant is, up in Evergreen, Colorado, not IP if it's just descriptive. The website template they use to develop their website is maybe a copyright of whoever developed the template, but it's not this restaurant owner's copyright. What they populate into the template may be their copyright. And just things that are common knowledge in the restaurant industry, that can't be protected as trade secret because it's considered public knowledge. So anybody have questions?
Yeah, would the pictures and the writing on the website be copyrightable?
Right, that would be, so the content that they populate into the template would be their copyright subject matter. The layout of the template, if there's any stock language, stock pictures, just formatting, that sort of thing would not be copyrighted, or at least not for this restaurant.
Are there often disputes about the definition of common knowledge, because you might think that your process is unique to you, and could they make somebody else think that it's common knowledge?
If they can show that it's out in the public domain, then it wouldn't be trade secret. And we'll get into the definition of trade secret a little bit later. But generally, if it can be shown that it is common knowledge, it's not a trade secret. You can only maintain something trade secret if it is indeed a secret. You keep it locked away, you take measures to make sure nobody else gets it. So let's start by talking about trademarks. Trademarks are words, slogans, and taglines. We have in the restaurant example, Mr. Ribs would be the words, slogan, and the tagline, get what it was, but Ribs Mountain Style. Graphic logos can also be a trademark. So you can actually have more than one trademark if you have the word, and then you also have a graphic, and then you also have a tagline. You might have 3 trademarks. And those are 3 separate trademarks. Other things that might apply are product packaging. Think about the unique shape of the old-fashioned Coke bottle. That could be a trademark. Color. If you walk into a hardware store somewhere and all you see is orange all around you, it's pretty likely that you're in Home Depot. Trademark for Home Depot. And even sounds in some cases. For example, the unique sound that Harley-Davidson motorcycles make is a trademark.
I thought they lost their sound.
The sound.
They read it, didn't you?
Yeah, but I thought they lost that.
Not as far as I know.
In court. This is
The unique sound that I mean,
it's
they
a twin,
can't.
it's a V-twin, and anybody that has a V-twin is going to sound, is going to sound similar to that, right? I thought they lost that battle.
I'm pretty sure that they still got it.
I'll
Check on that.
Yeah, because they tried to.
What about the business name? We talked about business name being separate from trademark, but trademarks may have elements of a business name. For example, Coca-Cola Bottling Company Incorporated is the business name, but you can see that their mark Coca-Cola is right in there, so they're not mutually exclusive. Just when it's used as a company name, it's a company name. When they pull it out and they say Coca-Cola Soda on the side of their can, now they're using it as a trademark. But it doesn't have to be part of the company name. Your company name can be XYZ LLC, and you can have whatever trademark you want. McDonald's, for example, there's McDonald's Corporation. They also have trademarks for McDonald's, but they also have Big Mac, which has no relation to the word in the company.